What starts as a routine dog ordinance case quickly turns into one of those courtroom exchanges that reminds everyone why emotions and legal procedure don't always mix. A man walks into court facing multiple allegations: no dog license, a dog running at large, and the most serious accusation, a dog-on-dog attack that carries potential criminal penalties. At first glance, it may sound like a simple animal control violation. But once bond conditions, courtroom authority, and personal frustration collide, the hearing takes an unexpected turn. Keep an eye on how the judge explains the defendant's rights, because those early moments become incredibly important later when tensions rise. Then watch what happens the instant the defendant begins challenging the court's bond conditions. Was he simply defending his dog? Or did he choose the worst possible moment to argue? Stay until the end, because this case becomes less about the dog itself and more about how courtroom rules, judicial discretion, and respect for procedure shape everything that follows.
Paul James Pernicano, 25B82401B and C and A.
Paul James Pernicano.
You have a 3-count charge here: animal violation, vicious act, dog at large, no dog license. You have the right to a lawyer. You want a lawyer?
No, sir. No, Your Honor. And I do apologize for my phone going off. First thing I did is turned it off. Yes, I'm sorry.
On December 28 of 24, it is alleged that you did have a dog on Morrill Drive near Dawnshire in Brownstown. No dog license is count 1, civil infraction. Dog roaming at large is count 2, civil infraction. And count 3 is a vicious act, dog on dog attack. It says that is a misdemeanor, punishable by up to $500 in fines, 90 days jail, costs, or all of those. You understand that?
Yes, Your Honor.
Did you sign the advice of rights form and read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
All right. You have the right to a lawyer. You still wish to waive your right to a lawyer.
Yes.
You understand all your rights.
Yes.
You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right. So I'm going to go ahead and enter a not guilty plea.
Thank you. For the dog tags.
Hang on 1 second. What kind of a dog is that?
German Shepherd.
Does anybody else live in the home with you?
No.
$500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. There's to be no contact with the owner of the other dog or prosecution witnesses. You cannot write, phone, see, text, email, or communicate with him or them or have anybody else do any of those things for you. Right? Fenced in yard or on a leash, accompanied by you, but also equipped with a muzzle. Do you understand that? Yep. Do you understand that?
Yes.
That's a condition of your bond. House, fenced in yard, muzzle, accompanied by you, on a leash. One of those 3 things. You understand that?
Yes.
And I can tell you.
My dog guilty before.
Here's an important legal point that often gets misunderstood. These restrictions are bond conditions, not a final judgment that the dog is legally vicious. Courts frequently impose temporary safety measures while a case is still pending, especially when allegations involve injuries or attacks. That allows the court to reduce potential risks before all the evidence is presented. But notice how the defendant immediately interprets the conditions as a declaration of guilt. That misunderstanding sets the stage for the confrontation that's about to unfold. What do you think? Would you have calmly accepted the temporary restrictions until trial? Or would you have spoken up immediately?
Pardon?
You're making my dog guilty of this offense before.
Really?
Yes, because he's not a vicious dog by far. You don't know the situation, Your Honor. You do not. And it's unfair. Those people that actually,
Slow down.
the people that.
Slow down.
Sorry. The people that.
Slow down. It's my turn to talk.
Thank you.
They don't pay me enough to argue with
I hear
people.
you,
Let's,
Ron.
hang on a second. I want to make clear that you understand this. I do not argue with people.
I'm not arguing.
And they're not going to argue with me. And if you think I'm unfair, go out in the hallway, tell people, go on Facebook, go out in the parking lot, tell whoever you want, whatever you want, whenever you want. I could care less. You understand?
Yes.
This is a condition of bond. There's not a judge worth 14 cents in the country that wouldn't order this based on the little information that I have. So if you think it's unfair, that's too bad. I could care less. If I find out you're not complying with the bond conditions, we're going to have a big problem, you and me. Do we understand that?
Yes, Your Honor.
Good.
This exchange highlights one of the biggest realities inside any courtroom. Judges have broad authority to enforce order, especially during bond hearings. Once a ruling has been made, repeatedly arguing with the judge rarely changes the outcome and can sometimes make the situation worse. Notice that the judge isn't deciding whether the defendant is guilty, yet he's emphasizing compliance with temporary court orders while the case moves forward. It's also interesting that the judge reminds the defendant multiple times about his right to hire an attorney, reinforcing that legal representation remains available even after today's hearing. Do you think the judge handled this firmly but fairly? Or was the response more aggressive than necessary?
If you decide you want a lawyer going forward, you can fill out a petition for one if you can't afford one. If you can afford one, you'll have to hire your own. But I'm not about to argue with somebody about a bond condition that is so customary and so common in these types of cases. You got it?
Fair enough, Your Honor.
When they quadruple my salary, maybe, just maybe, I'll argue with people, but not until.
I appreciate it.
Good. Give me a pretrial date, Lisa.
February 12th at 10.
February 12th at 10. Give them a copy of the bond sheet. Give them a copy of the notice. Again, if you decide that you want to hire a lawyer, you can. If you decide that you can't afford one and want one, then you can fill out a petition for one. Good luck.
Thank you, Your Honor.
Where's Mr. Baldwin? Is he left again?
Sorry. I have bad leg.
In the end, this hearing wasn't about determining final guilt or innocence. It focused on arraignment procedures, informing the defendant of his rights, setting bond conditions, and making sure public safety measures remained in place while the case proceeds. The defendant strongly disagreed with the restrictions, believing they unfairly labeled his dog before trial, while the judge repeatedly explained that these conditions are standard practice in cases involving alleged animal attacks. It's a reminder that temporary court orders are designed to manage risk, not necessarily to predict the final outcome of a case. Whether you agree with the judge's approach or sympathize with the defendant's frustration, this hearing shows how quickly emotions can escalate when legal procedures collide with personal beliefs. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.